Welcome to the Truth and Liberty Show, where trusted leaders bring biblical insights to important issues to help you stand for truth and effect godly change in our nation and in our world.
Welcome to the Truth and Liberty Livecast. I'm Richard Harris, your host today, and just so thankful that you could be joining us. Today's program is going to be devoted to an area that's near and dear to my heart, which is the impact of progressivism, sometimes called secular humanism, and definitely Marxism and communism on America's legal system, especially our courts. There was a Marxist, a communist in Germany named Rudi Deutsch, who in 1967 coined the phrase marching through the institutions. He said that in order for Marxism to take over the West, there has to be a long march through the institutions. Deutsch's phrase was picked up by another Marxist named Antonio Gramsci, or used by him. This long march through the institutions has been going on in the United States of America long before Deutsch made his comment. It actually is about 150 years old. And you know, Marxism, when we say that, sometimes people today, young people today, don't even really know what we're talking about. But there was a man named Karl Marx back in the 19th century. He and some of his cohorts were basically atheists who looked at the world as a zero-sum game, and that life is all about material gain and what you can get. And they, in their cynical outlook without God in their lives, came to the conclusion that all the world is oppressed, that you have the vast portion of the population is in the proletariat, and the very small minority of the population is called the bourgeois, and the bourgeois oppresses the proletariat. The bourgeois are the haves and the proletariat are the have-nots. The bourgeois, they're the ones that own what Marx called the means of production. The proletariat is the working class, the average man or woman who's trying to make a living and make ends meet and take care of his family, and that he's being oppressed and deprived of the means of his production and the fruit of his labor. This sort of class mindset is the undergirding philosophy of communism and Marxism. But in the last 20, 30 years, though, even longer than that, 40 or 50, Marxists have now evolved their theory from not just economic groups into all kinds of groups, into racial groups, into, of all things, sexual orientation groups, right? Where everybody is a part of a group and everybody is their identity is tied to their group. In fact, you don't even know who someone is except for the group they're in. So the group defines the person. And so all the people that want to, or I should say choose to feel oppressed, blame these so-called oppressors for their condition. It comes out of strife and envy, and it results in envy and contention. And these forces of envy, contention, and group identity and subversion have been working aggressively in the United States of America to undermine our republic, which is based on the Bible, for 150 years. And the socialists have recognized that Christianity, the Bible-believing Christianity, is their opposition. It is the worldview that opposes their distorted view of reality. And they have recognized that Christianity must be overturned and must be subverted. It was very hush-hush for many, many decades, but in the last 15 years, 20 years, the left has come out in the open, and Christianity is now the acknowledged enemy of progressive Marxists. One of the most effective avenues of this assault on our institutions has been in the field of education, particularly colleges and universities. The vast majority, I think it's upwards of 90%, of all college professors in America today are liberals, progressives, and if truth be told, would confess to being Marxists. But almost all of them are Democrats, to say the least. And it's been especially acute, not just in colleges and universities, but in our law schools. And I want to talk about our law schools. As you may know, I am an attorney. And the thing that you need to understand about law in America especially is that in America, our system of government, in fact, our entire nation, was founded on a concept called natural law. This idea originated, as best I can tell, with an English jurist named William Blackstone. Blackstone wrote in his two-volume work called Commentaries on the Laws of England. So Blackstone's Commentaries is what we call it by shorthand. It was the seminal source of authority. It was what every lawyer in England and America had on his bookshelf, if you will. Super authoritative. And Blackstone, in the beginning of his commentaries, began discussing what is law and what's the nature of law. Blackstone said that human beings, man, if you will, is a created being. And as a created being, he is naturally dependent for all things on his maker. And so it's incumbent upon man to discover and know the will of his maker, because he's obligated to obey the will of his maker in all things. So then Blackstone began to talk about how can man know the will of his maker? And he said the maker has, in other words, God, has revealed his will to us in nature. Blackstone then went on to say, but our minds have become darkened through the ages. And because of that, we're not able to discern the will of our maker in everything just by looking at nature. Although we can, some things, we're limited in our understanding. And so our maker, being good and kind and gracious, has revealed his perfect will to us in another place. And that place, Blackstone said, is the Holy Scriptures, the Bible. You can see this concept of natural law in our Declaration of Independence. It is the birth certificate of the United States of America, the organic document that gave rise to our nation. In there, our founders said that we are declaring our independence because we are entitled to do so by the laws of nature and nature's God. In other words, every human being, every group of human beings has the right to determine for themselves how they will be governed. And we are going to make that determination on our own as Americans, because the government we had at the time, the founders said, has become destructive of the purpose of government. They went on to say that all men are created equal and endowed by their Creator with unalienable rights, among which are life, liberty, and the pursuit of happiness. And that it's the duty of government, or the role or job of government, to defend, or as they said, secure those rights. And the government of Great Britain had become destructive of those ends, so they were entitled by God to alter or abolish it. Now, guys, this is the undergirding of the United States of America. It's what all American law is based on. But 100 years later, Charles Darwin came on the scene, and his theory of evolution, naturalistic, atheistic evolution by chance, began to spread. I like to say that it was the coat hook, if you will, on which intellectuals who wanted to disregard the obvious fact of a creator could hang their coats. They could put their ideological framework on that hook. At last, we've got a theory. We've got a theory that sounds like science that we can rely on to push God out, to reject the obvious fact of a creator. And this concept of evolution permeated American intellectual circles, our colleges and universities, and entered into our law schools. And it began to manifest this evolution concept, godless evolution, in the law in this way. In that our scholars, instead of saying, yes, there's natural law, and yes, all of our laws made by man must conform to that natural law. No, you really can't know if there's a natural law. Maybe there is, maybe there isn't. You can't know if it is. But really, we can make our own law. This idea became known as positive law. Legal scholars like Charles Evan Hughes and Oliver Wendell Holmes, who now have law school buildings named after them, these guys called this positive law, and they set about to be the ones who decided what law is and should be. Charles Evan Hughes said, "We are under a constitution, but the constitution is what judges say it is." And then along came a concept popularized by Woodrow Wilson and a professor named Howard Lee McBain, who wrote a book about it. that the Constitution was intended by our founders. You know, our founders, they were really intelligent guys, really wise. Yes, we revere the Constitution. They were so wise, in fact, that they decided that the document should be a living document, and a document that should be able to change with the times. Disregarding, of course, the fact that the founders built into the document the means by which it could be revised through the will of the people. Nevertheless, our judges, with their evolutionary mindset, our legal scholars, our law schools, cabbaged onto this living document idea, and it began to spread throughout our judiciary. And it entered into our courts and into the Supreme Court precedent. And it has manifested in the modern era in several different ways, where our courts have jettisoned the traditional understanding of our rights and our liberties and of the meaning of the Constitution, even of the fundamental institution of family, gender, sex, and so on. I'll give you 3 areas. Let's talk first about separation of church and state. Beginning in 1947, and then it shifted into high gear in the 1960s, the United States Supreme Court began to insist that all government activity must be strictly separated from church and state. A strict separation, and they said, which we cannot tolerate even the slightest breach, they said. So they started striking things down which had been legal and customary and understood as acceptable for 200 years. Things like our children praying before the school day. Things like our children in school reading the Bible, or the posting of the 10 Commandments on the school wall to remind children about the inherent, unalienable, or inviolable moral law of God. Teaching of creation became illegal. We became a schizophrenic nation. On the one hand, our founding document says we're created and endowed by our Creator with unalienable rights. This is the fundamental premise of our nation, and yet we can't teach our kids in our public school that they were created? The court held in 1980, you can't post the 10 Commandments on the school wall anymore. How about abortion? Where suddenly in 1973, despite centuries of common law and centuries of statutory law in America, holding that abortion was a crime, certainly after a certain time period, like when the baby first began to be quickened, if you will, move in the womb, or other periods, but abortion was generally speaking illegal in America. The court suddenly found all of a sudden a right in the Constitution, in something called a penumbra of the Bill of Rights. I don't have time to tell you what that crazy concept is, but suddenly women have an unalienable right to kill their babies in their womb. Or how about marriage, where in 2015 the United States Supreme Court said, oh, this living Constitution, we didn't know it, until now, but 230 years later, we finally found it, that the Constitution guarantees that 2 people of the same sex can also enjoy this sacred institution called marriage, something which no civilization has ever endorsed and went on to thrive and succeed. But we're going to do it because we know better. Well, guys, the good news for you today is that we are seeing great progress in the United States Supreme Court and in our federal courts on these questions and on these issues. We are seeing significant progress as Donald Trump especially had an unprecedented opportunity, and he fulfilled it by appointing conservative, strict constructionist, and original intent judges at all levels of the federal judiciary, including the United States Supreme Court, who have begun to roll back some of these concepts, some of these decisions. As you know, Roe versus Wade was overturned in a massive landmark decision of Dobbs versus Mississippi. But there's been a lot of progress in other cases too. And this is a really, really important area because, presidents come and go, members of Congress come and go, but the Supreme Court, it takes a whole lot longer to change. It takes a whole lot longer to change the precedent that they establish. And so if we're talking about long-term change and a long-term restoration of America to its founding principles and to the common faith in the God of the Bible in this country, then we need to change the judiciary. And I am really excited that I think we are beginning to see that happen today. But it's going to take more than just one president, more than just one case. It's going to take a long-term, steady commitment. And I'm super pleased today to be able to bring on the show one of my heroes, actually. He may not know this, but he's one of the most influential constitutionalist attorneys in America, has had a major impact supporting freedom of religion and freedom of speech in our country. And his name, ladies and gentlemen, his name is Michael Farris. And Michael was the founder and president. He's the founder of, excuse me, I've lost my place in my notes, Homeschool Legal Defense Association and Patrick Henry College. He was also the past president of Alliance Defending Freedom. He's appeared before the United States Supreme Court multiple times, before many federal circuit courts, many federal district courts, and many even state Supreme Courts, and has done more, I think, than almost any attorney in America to return us to our original foundations that our founding fathers intended in terms of the Constitution and our founding principles. And so I'm really excited to be able to sit down now with Michael Farris and talk about these issues. Before we go to that part of our show today, though, I wanted to let you know about our special gift available to you at no charge. It's a booklet by Andrew Womack called A Message from an Old Man. Actually, a message to teenagers from an old man. The old man is Andrew Womack. So, sorry, Andrew, I don't think you're old, but this is your book and your title. So, but Andrew has written this little booklet for teenagers to share with them some pearls of wisdom that he's gained over his 70 plus years of life and ministry. And if you want to bless your teenage sons or daughters, nieces or nephews or grandchildren, go to our website at truthandlibertygtn.com and you can get a copy of this at no charge. All right, folks. We're going to take a break, share a little bit of information, and after that, I'll be right back with our guest, Michael Farris. I want to invite you to join us for the annual Truth and Liberty Awards Banquet on May 2nd, 2025 on the campus of Farris Bible College right here in Colorado. We're going to be honoring two Americans who've stood courageously for biblical values. Abby Johnson, the former clinic director for Planned Parenthood, whose life story was the subject of the movie Unplanned, is going to get the Samuel Adams Award. And then Lieutenant Colonel Teresa Long, a United States Army flight surgeon who stood up against mandatory vaccines in the military, is going to receive the Samuel Whitmore Award. There's going to be a powerful keynote message delivered by Seth Gruber, the founder and author of the 1916 Project, an eye-opening expose about the foundations of the abortion and LGBT movement in America. Tickets are $125 each and can be purchased on our website at truthandliberty.net. Now, this event is a fundraiser, so sponsors are welcome. Make plans to join us in the Rocky Mountains on May 2nd for this inspiring and beautiful evening. All right, welcome back to the Truth and Liberty Show. And as I said, my special guest today is Michael Farris, one of the leading constitutional attorneys in America, former president and CEO of Alliance Defending Freedom and the founder of Patrick Henry College and the Homeschool Legal Defense Fund. Michael, thank you for joining me on Truth and Liberty today.
Richard, my friend, it's great to see you again. Thank you.
Wow, what an honor to have you. Mike, you've been practicing law for what now, over 40 years?
Yeah, it'll be 47 years this year. And so closing in on 50. I was 7 when I became a lawyer.
Yeah, I was going to say, of course, you were a child prodigy. So
yeah, something like that. I was as young as you normally get. I think I was 24.
Yeah.
Something like that. Yeah.
Well, that's fantastic. And you've had quite an illustrious career. I think, when you became an attorney, Roe versus Wade was still sort of a relatively new case, wasn't it? Maybe 9 or 10 years?
Yeah, it was. It was, that was a 1973 decision, and I became an attorney in 76. And, I was taking constitutional law as an undergraduate student when Roe was decided. And I had the good blessing from God to, at a secular state school, to have a constitutional law professor who was an originalist. And so he taught us, right, he wasn't pro-life on a personal level, but he was very much one who taught how the court was legislating from the bench, and that was improper for judges to do so, and that they should be following the original meaning of the Constitution. And he pointed out how that case did not qualify for an originalist kind of decision. So So from day one, I was an opponent of Roe versus Wade on constitutional grounds, and my moral understanding of it deepened as my wife and I had our first child in 1975. That's when I really became ardently pro-life because of the morality of it. Before that, I just hadn't thought deeply about it, and so that became really a very important driver. To have any role in that with ADF, which we were co-counsel of the state of Mississippi in the Dobbs case, that was a great, great thrill of my life to be able to have a role in that case.
Yeah, that's really quite amazing, actually, that sort of your legal career sort of spans the whole history of Roe versus Wade, and to actually be in on the reversal of it in such a pivotal way is just really incredible. Well, Mike, how has the legal landscape changed since you've been, and I'm talking about constitutional law, how has it changed since you've been an attorney? It feels to me like we have really turned a corner in the last few years, or begun to come around the bend, maybe in some good ways. But I'm really curious to know your perspective on that.
Well, yes, indeed, we've made real progress in two different ways. One which is strongly recognized, and one which is less often recognized. The one is at the judicial level, and frankly, this became popularized in a way that became really important by Ed Meese when he was the Attorney General of the United States under President Reagan. He was the one that really stood up and started arguing forcefully for the original meaning of the Constitution. It used to be people talked about strict constructionism, and that's, I get what people are trying to say when they say that, but it's not the best way of saying it.
Yeah.
So the more precise way of saying it is that the words of the Constitution should always mean the same things as it meant to the generation that wrote and ratified the various parts of the document.
Yeah.
So most of the Constitution by the founders, the 14th Amendment by the people who wrote that, and so on. But it's just a rule of law. That is, when you interpret a deed, you want to know, what did the guy who wrote the deed mean by, you follow the creek line down from the big rock down to the cherry tree. Well, 50 years later, if the cherry tree and the big rock had been moved, you do your very best to find out where the big rock and the cherry tree were and follow the original meaning of the deed. And that's the same thing for the Constitution. Following the original meaning derives from our support of the idea of a Republican form of government, which means the people that make our laws are the people that we elect, not unelected officials. Unelected officials should never be allowed to make law in a republic. And whether it's the EPA or the UN or the Supreme Court of the United States or any other court in this country, they should not be making law. They should be, the UN should have no role whatsoever in our country. But in terms of making law, if they want to have a nice debating society for someplace, okay, that's a little different. But they shouldn't be making law. But the others have a role in our legal system, but not making the law. Making the law, all legislative authority in Article 1, Section 1, is vested in the Congress of the United States, the people's elected representatives. Why? Because the people have a right to throw the rascals out if we don't like the law they're making.
Absolutely. And so this idea of original intent, it's fundamental. I mean, first year of law school, you're taught about rules of construction. And when you're looking at a statute, you're supposed to, if it's vague or ambiguous, you try to figure out what the legislature intended. So you go to the debates, or you go to the whatever was going on at the time that it was the genesis of the new law. If it's a contract, like you said, with a deed, you figure out what did the parties mean. But somehow with the Constitution, we've jettisoned that concept. How did that happen historically? Well,
as you said in the opening, the theory of evolution really played a major role in that. Is that, if there is no foundational truth, if all things are involved, truth evolves, people evolve, beings evolve, whatever. Once you buy in, there is no God, and truth is relative, all bets are off. The legal system cannot exist in the traditional fashion in that environment. And the second thing, and I got so deep into the originalism, I forgot to tell you that the other way it's really changed is that when I started as a young lawyer, I was in private practice until 1980, from 76 to 80. And then I started doing nonprofit Christian legal work. When I started doing this full time, there were 3 lawyers in America doing full time, essentially constitutional Christian oriented law. John Whitehead, William Ball in Harrisburg, Pennsylvania, and me. That was it. And now, wow, we're still teeny tiny compared to the ACLU and others, but Alliance Defending Freedom has 400 employees or 420 or something like that now. It's 400 when I left. Liberty Counsel, First Liberty, Beckett Group, Pacific Justice, lots of good groups out there. Mm-hmm. And they all need to double in size. And, if there are any of their donors listening, give them more, give them all of them more money, because we still have we're so far behind the ACLU in size. But the fact that we're in there fighting, and that we, ADF, while I was CEO, had 13 cases in the Supreme Court, and we won 12 of those cases. ADF has 3 cases in the Supreme Court right now, and I know that Beckett has cases in the Supreme Court. I wrote an amicus brief for one of the Beckett cases here last week, and I wrote one for an ADF case that's in the Supreme Court last week. So there, we've got a much, much better team on the field. So Christians are finally starting to show up, and that matters. And so that's one of the huge changes in my life. And so one of the reasons that the conservative judiciary can do the good that it's doing is there are conservative Christian lawyers bringing the right kind of lawsuits with high levels of professionalism and doing an excellent job of putting these cases on the table so that conservative judges have a shot at doing it. Because judges can't go just make up cases out of thin air. Somebody's going to bring them a case.
Right. Well, yeah, it's amazing. So I didn't know, I knew there'd been a growth in nonprofit Christian defense organizations, but I didn't know that there were only 3 lawyers, not law firms, just 3 lawyers when you started. That's really something. But in the last few years, Mike, we've seen quite a few important cases that seem to be sort of going back to more expansive view of religious liberty, and maybe, hopefully, to some extent, an originalist understanding. Can you comment on that, and what do you think are the most important cases in that regard?
Well, sure. The religious liberty has 2 different phrases in the Constitution. There's the Establishment Clause, and there's the Free Exercise Clause. There's excellent progress been made in the Establishment Clause. And the Coach Kennedy case was the culmination in many ways, although there were other cases that preceded that, including the Town of Greece case that ADF argued. Actually, Tom Hungar is a really good friend of mine, argued that for ADF. And so there were a series of cases, but in the Coach Kennedy case, the court finally said, haven't you been listening to us? Lemon's not good law anymore. Lemon was the one that gave us the 3-part test and really put life in the separation of church and state phraseology, which is not the best nor the most accurate, not even really that accurate. I mean, there's a little bit of truth in it, but not very much. And the better rule is you can't have an established religion in this country. That's what the Establishment Clause says. And an established religion doesn't mean all the negative antipathy that goes against Christian people. That you can't treat Christians as second-class citizens out of this crazy notion of separation of church and state. And that's what happens a lot of the times. In fact, that was the position I argued in a case in an amicus brief last week in the Supreme Court for ADF, that I just focused on the Establishment Clause there that said Oklahoma's treating Christian-oriented charter schools as second-class citizens. Everybody else could do charter schools, but not religious groups. And a case that I argued in the Supreme Court in the late 1980s, Winters versus Department of Services for the Blind, ruled 9-0, Justice Thurgood Marshall wrote the opinion, that it does not violate the Establishment Clause for Christians to participate in broad programs of educational assistance. My case involved a kid going to Bible college and was attending, Inland Empire School of the Bible in Spokane, Washington. And the court held that doesn't violate the Establishment Clause for him to participate in this program. And so that nonsense doesn't go away easily, because that case is getting close to 40 years old. And we still are battling over these things of treating Christians as second-class citizens. On the other hand, the Free Exercise Clause, we still got a lot of work to do. The decision of Employment Division versus Smith from 1990 was a very bad decision, and it put free exercise in a deep hole. And that's why we have the Religious Freedom Restoration Act that I helped write. I was the co-chairman of the group of lawyers that wrote that, and it was a really interesting episode. It was left-right coalition. Every religious group that you could imagine was involved. What really happened is Jewish groups went to people like the ACLU and said, "We've been carrying your water for a long time. This Smith case is horrible, and we need to fix it, and we demand that you come help us." And so the ACLU was there, and credit to the Jewish organizations. They got them to do the right thing. It was like a broken clock. The ACLU was right once in their life, and they supported the Religious Freedom Restoration Act. So, Mark Stern and I, he was from the American Jewish Congress, but the two of us were the co-chairman of the drafting committee of that bill. And when Hobby Lobby won their case in the Supreme Court of the United States that they couldn't be forced to give abortion coverage in their health insurance, they should have been able to win on the First Amendment, but they didn't. They won it on the Religious Freedom Restoration Act.
So can you clarify, what is the holding of the Smith case?
It says that you can't get a religious exemption from a neutral general law. Let me translate that. Yeah. If the law says you can't discriminate on the basis of sexual orientation, then Patrick Henry College, which I founded as a Christian college, that we can't discriminate on the basis of sexual orientation in our hiring of faculty members or other staffers at PhD. In fact, we don't hire anybody that's not a born-again believer, and both in profession and in lifestyle. But nonetheless, Patrick Henry College, if it was just up to the Smith decision, there's other arguments we can make on freedom of association and so on. But on free exercise itself, Patrick Henry College would lose that case, because the Smith case says you can't. The law on sexual orientation non-discrimination it wasn't aimed at religion. It was just a neutral general principle, applies to all businesses. And so if it's applied to all businesses and there's no exceptions, then it's a neutral general law. Or another example I like to use is it's illegal to serve alcohol to minors in most places and most times. If a church, I go to a church that serves grape juice, but if I went to a church that served actual wine, then you couldn't serve wine to minors if somebody wanted to force the law literally. And to say, no, that you can get a religious exemption to that law. No, you can't. Because Smith says if it's a neutral general law, you can't get a religious exemption. That affects homeschoolers. It affects all kinds of people. And so that law that decision was a very, very dangerous proposition, because otherwise, the Amish should have lost the case, Yoder versus Wisconsin, or actually it's Wisconsin versus Yoder, and so the ability to not force the government into our religious decision making really depends on the ability to say, you can have this law in certain contexts, but when you apply it to religious groups or religious individuals, you gotta do it differently. So that's been a very, very dangerous decision. A lot of my life's been devoted to getting rid of that case.
Well, let's shift back, if we can, to Establishment Clause. So Kennedy versus Bremerton High School expressly overturned the Lemon test. And right. So Lemon, which I wrote my law school note on for law review, is gone. But what took its place? What's the new standard for whether government action violates the Establishment Clause?
history.
Ah.
And that's the way it should. That's the correct standard. Is and the way I like to phrase it, the court hasn't phrased it exactly this way, but this is my phrasing: is that your right to the government's ability to engage in religious activities is judged by whether this kind of activity was practiced in the early days of the American Republic. And so if you want to, for example, prayer in Congress, did Congress pray? Well, the very Congress that passed the First Amendment prayed every day.
Mm-hmm.
And so there's the history on that. And, downwind from that, why do public schools have to obey the rule of the Establishment Clause? It's because the court has said the phrase that says Congress shall make no law respecting an establishment of religion also applies to state governments, and public schools are a derivative of state government. So my contention is, well, public schools have to follow the same law as Congress on the First Amendment. And if Congress can pray, as long as it's not coercive, then the schools can pray. And again, I think that it would be an absolute right for anybody to opt out who didn't want to be a part of that. But to say you can't do it at all, especially at a graduation or something like that, is, you're being two-faced about the Constitution. There shouldn't be one set of rules for Congress and a different set of rules for every other government agency. So that's an example of how that works, is history. What did they do?
Yeah, well, there are several states that are beginning to restore some of the practices, I think to a degree, that used to be commonplace in the country before the 1960s, like Bible reading in school or prayer or Ten Commandments being displayed. Now they're being a little bit delicate around the edges of it, but do you think that ultimately the Supreme Court is going to hold on to that standard? Or did they mean what they said? Are we going to be able to restore these practices in our public schools?
Well, not the most clear religious, like reading the 23rd Psalm or something on a daily basis, which was one of the old cases, or the Lord's Prayer or something like that. That's not going to happen. Not in the next 10 years, let's say. But some of the stuff around the edges, yes. The Establishment Clause cases do not generally require proof of coercion. The real test is, can we get away from the no coercion rule? Because that's the real rule, is if we're forcing somebody to engage in religious activity, that's wrong. No one should ever be forced to engage in religious activity. And so what we need to do is to be able to describe what is coercive and what's not coercive. And so, there would be things that, and just as a parent, I go outside my constitutional law role for a moment. Even if they were reading the Bible at the beginning of the school day, which the National Education Association advocated in the 1951 publication called the American Civics Handbook, they gave Bible passages not only for public school reading, but for public school memorization. The NEA did that in 1951 book. But in any event, I don't want parents thinking that if there's a minute of prayer at the beginning of the day or a minute of Bible, that what happens in the next 5 hours and 58 minutes doesn't matter. And so it's the whole experience in the public schools. As long as they're going to teach kids that there is no, there are more than two genders, there is no right and wrong. We all evolved from common ancestors, from single-celled creatures and on up to humans finally. And when they teach them error for the other 5 hours and 58 minutes, the Bible says, since they did not think it worthwhile to retain the knowledge of God, God turned them over to a depraved mind to do that which ought not to be done. So I don't like putting a Band-Aid on the first 60 seconds of the school and calling it good. If there's going to be a reform, it's got to be a real reform where we get all this nonsense out and put academics in a kind of a God and country, you know, you know, neutral within the God and country framework,
Right.
kind of a situation. And so, but what's going on in public schools today is so bad. I don't want anybody thinking that I believe, at least, that a minute of prayer at the beginning of time will fix it.
I agree with you, but on the other hand, it's the things that we're seeing, the outrageous stuff, aren't they intellectual, philosophical descendants of the rejection of God in the first place?
Absolutely. So it's a good start, but I don't want people resting on their laurels.
Right.
You know,
Absolutely.
They say, okay, well, we've taken care of the opening minute. Now we can rest. No. If we're going to reform, let's reform. And it's got to be thoroughgoing, because it's a worldview that's being taught. And the idea that it's not is just, it's crazy that one of the cases I just filed an amicus brief on is the Mahood versus Taylor case in the Supreme Court, which is Montgomery County, Maryland, that has a series of textbooks. They call them storybooks, and they're for little kids, kindergarten, first grade, second grade. And they're all about LGBT training these kids. And the teacher's training officially says things like it's in the court record that if a child says my religion doesn't permit this, the teacher is to disrupt the child's belief by teaching them this, that other, it gives them techniques on disrupting the child's belief. And the brief I filed in the court is that the only thing that the Supreme Court has said is an absolute right, is the right to believe. And it can never be a legitimate function of government to disrupt the beliefs of children. Just not legitimate, period. No exceptions, no carve-outs. There's no justification. There's no interest that justifies that. You just can't do it. Mm-hmm. And so that's a case pending in the Supreme Court of the United States right now. And it's not just Montgomery County, Maryland. It's the vast majority of public schools in the country are doing the same thing.
Well, Mike, let's talk about I think the case that you referred to a minute ago that you're handling, or that you filed a brief in. Is it the St. Isidore of Seville Catholic virtual school versus Drummond?
Yes. Yeah, that's one of the two briefs I filed. Actually, I wrote them both last week, but I filed them both this week. So, it's yeah. And in that case, Oklahoma says anybody can start a charter school, but not religious groups. And the Oklahoma Supreme Court said it violates the Establishment Clause. So I didn't get into, in an amicus brief, the best way to do it is not try to rewrite a whole, you take one issue and go in depth.
Right.
And so since I argued and won a 9-0 Establishment Clause case on educational, on the Establishment Clause in the educational arena, I went into depth in that because that's my background and that's my expertise. And so I took the Witters case and exploded it and basically said you can't use the Establishment Clause as an excuse to treat Christians as a second-class citizen. And that was the essence of my brief.
So if your position prevails in that case, then the state of Oklahoma would be funding a purely religious school, would be paying the expenses for a Catholic school. Just as they would, as they were paying for Larry Witter's education, going to Inland Empire School of the Bible to become a pastor. But the rule is that's looking at a particular person. You look at the program as a whole. The Establishment Clause is violated by a program as a whole. What does the program as a whole do in Larry's case? It was help blind. What does the charter school program as a whole do? It lets anybody who wants to start a charter school as long as they meet certain academic standards. And so the question before the court is, can you say anybody can do this except religious people? And so, it's not being funded because it's a Catholic school. The question is, can they kick them out solely on the grounds that they're Catholic? Because they meet every other standard. It was a case that ADF handled while I was there. The Lutheran Church School case involved playground equipment. Trinity Lutheran is the name of the case, and versus Comer. And it was playground safety equipment. And Missouri said anybody can participate in this playground safety program as long as they open their playgrounds up to the neighborhoods, except churches. Mm-hmm. And this church was opening its playground up to the neighborhood, and it was a
Christian preschool, and they couldn't participate in this playground safety program solely because they were religious. And so, yeah, the money went to a Lutheran church, but it was for playground safety. Everybody can participate, just like the GI Bill. Yeah, the GI Bill goes to pay for people's education to go to seminary. Some of the greatest pastors of certainly my parents' generation were trained through the GI Bill. Their education was paid for. Well, there's government paying for people who become pastors, but they were paid because they were GIs and they earned their benefits, and you just can't discriminate them because they apply their broad program benefits to a religious context.
Mm-hmm. Well, Mike, I'd love to talk about that more, but I definitely want to give you time to talk about your challenge to the Johnson Amendment. So as counsel now for General Counsel for National Religious Broadcasters, you have taken on, the elephant in the room, if you will, maybe one of the biggest problems we face as we try to get Christians and churches engaged in the public square, the Johnson Amendment. Can you talk about that?
Sure. The Johnson Amendment came from Lyndon Johnson, who was a U.S. senator who didn't like the fact that two nonprofits were putting out material opposing his primary election for the Texas Senate in 1954. And so he got a rule passed through the Internal Revenue Code that said 501c3 nonprofits, that includes churches and basically all charities, that they can't spend any money whatsoever supporting or opposing candidates. And ironically, 2 weeks later, approximately, his own campaign did a flyer to thousands of churches saying that they needed to support this good Christian man, Lyndon Johnson, against his opponent who was a Catholic. And so the idea is Protestants against Catholics. So Johnson's own campaign violated the Johnson Amendment within 2 weeks. But nonetheless, it's never about fair treatment. It's always about getting your own thing done. And so our contention is that it violates freedom of speech. The IRS's argument is that you don't have a constitutional right to have subsidized speech, and that they contend that tax deductions are subsidies. And they have a Supreme Court case that says that. But here's the counter argument. Every other kind of entity, business entity, for-profit companies, other nonprofits, for example, 501c6s are trade associations, like the Apple Growers Association, for example. And all of them can say what they want to say about candidates. They can't do it with deductible money. So the apple growers, they can deduct their dues to the Apple Growing Association as a business expense. So it's a deduction, just like a tax deduction to giving to churches. And the Apple Growers Association, if they spend 95% of their money on non-candidate activities and 5% on candidate activities, then 95% of the money that the apple growers give to the Apple Growing Association is deductible, and 5% is not. So there's an allocation. But if a church, spends $30 million, let's take a big church, $30 million, and $3 million goes to feeding the poor, and $27 million goes to normal, church kind of ministry, not the outreach kind of ministry, and $100 goes to support or oppose a candidate, then the church loses all $30 million in deductibility. It's not about the $100. And so if you wanted to say, well, you can't endorse candidates with subsidized money, fine. You figure out a rule to handle the $100. You don't lose your deductibility for the entire $30 million because of the $100. In every other kind of entity, for-profit and nonprofit, they have to allocate that way. And so the amount that you spend on candidates, which would, for churches, would never, most churches just want to get up and say this. My own pastor did this and our church got fined by the IRS for doing it. He said, the Bible has these standards on these 5 issues. The Republican platform has these standards on these 5 issues. The Democrat platform has these positions on these same 5 issues. Compared and contrast, and he said, I don't know how anybody can vote for a Democrat in light of what the Bible says about these issues when you compare the platforms. And for that, our church got fined by the IRS. Now, that's what we need. We people aren't going to we aren't asking for churches to be able to give money to candidates or to hold rallies or anything like that. Just the pastor to be able to say what he wants to say and say, here's what the Bible says. Here's what this guy says. Here's what that guy says. Here's what this party says. Here's what that party says. And just look at the principles, and we're going to stand for biblical principles. I think that we've got a really good chance. We're in federal district court in Tyler, Texas, which leads to the Fifth Circuit, which is a very conservative circuit. And if we win, there's no doubt that the Supreme Court of the United States will take the case. And so we'll have a Supreme Court case eventually, or unless the Trump Justice Department decides to that it doesn't want to fight and instead wants to find a way to reach a resolution in court. And that would, of course, be not as fun for me personally, but it'd be very good. Because I like to argue another case in the Supreme Court and win.
Well, I'm sure your enjoyment level's high on the priority list for the Justice Department, Mike. So, well, let's talk about that a little bit more. So, do you think that churches now they don't have to be 501c3s to be tax exempt, but they can be, and if they choose to be, and most are, do they have a First Amendment claim for that the Johnson Amendment is restricting their freedom of speech or their free exercise?
Well, we've made all those claims in the case, but just one small correction is that the IRS code makes all churches automatically C3s without even applying.
Okay,
you don't have to apply.
Yeah.
You just have to be a church. And so, so some do apply, but most don't. And so you are gagged from day one as a church with no choice. You don't get a choice to operate as another kind of entity. If you are a church, you're automatically put under the C3 rules. And so that's one of the elements of the complaint as well. One of the other elements is that we have about 50 pages of examples of nonprofits divided between newspapers and churches. There are hundreds of nonprofit newspapers in the country, including the Philadelphia Inquirer. And the Philadelphia Inquirer every year endorses Democratic candidates. Every year.
Is it a 501c3?
It is. It's a 501c3. And so that was really what was the hook that helped me figure out how to file this case and challenge, because people have been wanting to challenge the Johnson Act for a long, long time. And I think I found the magic formula by thinking of the Philadelphia Inquirer. I said, there is nothing in the First Amendment or in tax law that makes the Philadelphia Inquirer any different than Intercessors for America, which is a prayer group in Purcellville, Virginia. That's one of my clients in this case. And they put out a voter's guide. There's no difference. But one's illegal by the IRS, and the others, they turn their head. So it's legal with a wink and a nod. So, in fact, college newspapers, the IRS has said, they, in a formal opinion, are exempt from the rule, even though they're nonprofits, even though they're 501c3s. They've given college newspapers. Why? Because college newspapers are dominantly Democrat. And so they get away with it. So we're challenging it both on free speech grounds, free exercise grounds, and on the ground that the IRS is enforcing the law in a discriminatory fashion. Either way we win, if the court goes either way. But I think we've got a good shot on both of those theories, very good shot.
Well, in as applied, we were talking before we went live about how Democrat candidates go into churches all over America all the time, and nothing is ever done. And you said in the case, you've got a great record so far built on showing the disparate treatment between conservatives and Democrats under the Johnson Amendment.
Yeah, we have videos that we put the links into the complaint, where Joe Biden in April, right after the debate and before he bowed out, he goes to a church in Philadelphia, and the pastor's leading the congregation in a chant of "Go Joseph, go Joseph," and Biden gets up and makes a campaign speech, and the pastor endorses him. I mean, it doesn't get any more blatant than that. And it's okay. You can have the president of the United States, the sitting president, campaigning in a church, and it's okay because he's a Democrat.
Yeah, right. Well, and so, Mike, going onward from here, we started this show talking about, well, your career, but we talked about what progress has been made, some of it in the last few years. But how do we hold on to that progress? How do we keep it moving? Isn't it really the solution has got to be in part political, right? We've got to maintain the political will to win the victories, to keep the judges appointed that are going to do these things.
Exactly. The liberty requires eternal vigilance, and there's just no substitute for it. I live in Virginia, and Virginia's going to have a gubernatorial election this year. And Republicans won the last gubernatorial election, and Glenn Youngkin was seen as an overwhelming victor. He actually got 51% of the vote of the people who showed up, but he got 17% of the vote of the eligible voters.
Wow.
And if just do the math, if a quarter of the population, or even if it's just 17% of the population are born again Christians, and let's assume that half the people that voted for him the last time were born again Christian. Well, another 9 or 10% of the population that showed up, it would have been a blowout. It would have been, it wouldn't be close. And so the reason we don't control more than we do is because Christians stay at home. We stay at home a little more than the population at large. But the fact that we stay at home at all is shameful. If we would simply show up and vote our convictions on a regular basis, we would have great judges, we would have much better laws, the situation would be improving. We're never going to live in a utopia, because utopia requires one thing that will never happen under the Constitution. It requires the personal reign of Jesus in the flesh. That's the only way you get a utopia. Otherwise, you get a country built on the principle that everybody's a sinner and you can't trust anybody with too much power because of the sinful nature of man. And that's the premise that leads to freedom. And if you have checks and balances and federalism and enumerated powers and all the other features of the Constitution that built on that bedrock Christian principle of you don't trust anybody with too much power, then you have a free and great and prospering nation. But the utopia requires the personal presence of Jesus. It's going to come, but it's going to come independent of all of our political machinations.
Well, fantastic. Mike, thanks for joining the show today. It's been a real honor and a privilege to have you on. And we'll be praying for your cases and everything, and just really appreciate all you've done to restore liberty and restore us to our foundations here in this country.
Well, thank you, Rich. It's always a pleasure to be with you, and I've been to your great facility there, and I just think you guys are doing a great thing there, and I wish you the very best.
Thank you so much. Folks, I want to remind you today about the free product we have for you. It's called A Message to Teenagers from an Old Man. Andrew Wommack has taken some of the life lessons that he's received from the Lord in 55 years of ministry and condensed them down in this little booklet designed for your teenage sons and daughters, nieces, nephews, grandkids. Lessons like the foolishness of sexual promiscuity, the deception of rebellion, the dangers of experimentation, and some others. Get this today by going to our website at truthandlibertygtn.com, and you can get it for free there. Thanks for watching Truth and Liberty today, and we'll see you again next time.